Hello, everyone. This is Barrister Jannat Kalyar. I'm the moderator for today's session, and we're at the Women in Cybersecurity Conference 2021. Our topic of discussion today is the area of data protection in South Asia with a focus on Pakistan. We have a powerhouse panel with us today. We have Ms. Zaheema Iqbal, who is a cybersecurity policy expert, and then we have Ms. Shmyla Khan and Ms. Hija Kamran, who are very prominent digital rights experts or champions, if I may. And thank you very much for joining us. So data protection is something that we don't have in Pakistan. As we speak, there's no data protection law in Pakistan. And as you are, I'm sure, aware that in the past almost 2 decades, a number of iterations of the Personal Data Protection Bill have been proposed by the Ministry of IT, but not even a single version of the bill was tabled in the parliament. But it is expected that a revised version of the current bill that was proposed in 2020 will be tabled in the parliament soon. And hopefully we will have a personal data protection law by next year. When we talk about personal data protection in Pakistan, there are a few examples that come to mind. There have been a record number of breaches. If we talk about databases that are held by public bodies such as NADRA, and then there have also been data breaches at the behest of private companies as well. So this is a very serious issue, and the citizens of Pakistan, they've never really had a recourse to file a complaint if their informational privacy has been violated. And another problem that I see in the current draft is that it does not provide recourse to the citizens. So, for instance, if my data is being, it's being compromised, there is a certain level of accountability there in the bill. There is very basic standard of protection that the data controllers or holders they are expected to comply with. But when it comes to me seeking recourse or me seeking compensation, no such thing exists. There's no right to seek compensation, and this is a very big issue, because if we look at the GDPR or the Data Protection Act or the jurisprudence of the European courts, we see that they do award compensation in the form of material and non-material loss, even for distress to citizens whose privacy has been violated. So this is, I think, one of the very big shortcomings in the bill that that really struck to me. But now I'm going to move on to the questions. And my first question is for all the panelists. I think we can start with Hija. What do you think is the importance of a data protection legislation, particularly in the context of South Asia? And given the current situation in Pakistan, do you think it is needed now more than ever?
Thank you so much, Jannat. Thank you for the introduction and for having me here as well. I think with regards to your question, the important thing is that in Pakistan, at least, the data protection regulation was needed in the year 2000, when NADRA was actually formed. NADRA holds all the biometric data of every Pakistani citizen, which currently stands at 220 million and over 220 million people. So it was essentially like it was a long time coming, and the need was, very essential. And to the point, we saw how data breaches have happened. You mentioned and given a very important, a background of the kind of breaches that we have seen. For instance, the Safe City project data leaks that we saw, the private companies, for instance, the cinema data leak, and also multiple data breaches at Nadra itself. It was essentially needed years ago, but of course, as how it goes, it's better late than never. So at this point, I think in the context of South Asia, we've seen Pakistan has Nadra, India has something called Aadhaar. I'm sure there are other countries, for instance, Bangladesh, Nepal, and every other country have something of the sort that requires data protection. Even if there's nothing locally, even if there's nothing like Nadra or Aadhaar, but data is being collected by entities, by private and public bodies constantly. So it does require data protection, and not just in South Asia, but also in Asian countries at large, because Asia does make most of the population of Pakistan, of the world. So data protection is required and is essential and is needed whenever it's offered, essentially.
Shmyla, would you like to answer now?
Yes, thank you. And building off of what Hija was saying, I think it's essential that we talk about the sort of government overreach that is happening in a lot of South Asian countries. So the surveillance capacities and the capacities of governments to sort of surveil its citizens, collect huge amounts of data on them, and then predicate a lot of services on the basis of that data has become a big issue. And the prime example, obviously, is sort of the Aadhaar system, but we see this all over. And a lot of governments are now moving into the space of e-governance. So we see a lot of this happening in Bangladesh, and this means that more user data is being collected, more of it is being used. So the sort of we see there's no framework or overarching framework, legal framework, to make sure that this data is not misused beyond the purpose of which it is collected, and all of the data protection principles. And now we see this sort of turn towards technology even more during the COVID crisis. So a lot of things, for example, like even the vaccine rollout, a lot of it is taking place through technologies. Countries are developing apps just so people could sign up and get information regarding the vaccine. That means more and more information is being generated. And we see the impact, as Hija also mentioned, of data breaches disproportionately impacts marginalized populations. And I know that it's become almost a cliche to say something like this, but this has real life impacts on sort of people's lives. For example, a simple data breach is obviously an issue if there's been a breach from the telecom side or from the government side, but it can lead to harm, for example, within the home when it comes to women. It can lead to revealing of someone's gender identity after they've transitioned, if they're transgender. It can also lead to targeting of religious minorities within a particular country. And because we see there's been a real shift in terms of governance, both in sort of much more starkly in India, where there has been a targeting of particular populations. So especially under authoritarian regimes, it's much more important for data protection and privacy protections to be in place. So yeah.
Zaheema?
Am I audible to everyone? Okay, Ji, thank you, Jannat, for the introduction. Data governance, ladies and gentlemen, it is an emerging challenge which is not only reshaping the global digital economy. Yes, there is no doubt in its inevitability that it is needed more than ever. Yes, it is, because data has become a resource which is significantly impacting how nations and societies they develop. Back in 2019, there was a report which says that there were more than 4.12 billion internet users across the globe, and that was 900% hike from last 2 decades. So we see that there is another example. Back in 2017, The Economist, it has rightly pointed out in one of its articles, and it said, data is to this century what oil was to the last one, the driver of growth and change. So we see today that the flow of data, it is by using these digital platforms, it is it is at unprecedented rate, and it has not only created new businesses, new infrastructures, more appropriately to say, if new politics and new economies as well. Coming to the South Asian point of view, this region is home to some of the world's fastest growing economies, and where data subject is seldom aware of its right, by whom its data is being used, either its custodian, be that data controller or data processor, be that nation state or technology companies. So it would not be wrong to say that time has come when the strength of colonizer would be measured or determined by the vastness or the amount of data colonized. And South Asia, being the most populous region, it would be home to one of the largest amount of data being generated in the days to come. So I'd like to end my point with that colonialism has been reinvented with the use of latest digital technological evolution. Yes, we need these regulations more than ever today. Thank you.
Thank you very much, everyone. So my next question is to Shmyla. Shmyla, what in your opinion are the key features of the Personal Data Protection Bill 2020?
Yeah, so this bill has been through, as Jannat also mentioned, several rounds. The initial draft that came out in 2018, the definition of personal data was quite restrictive. But as it's gone through several amendments, some of the criticism that was directed towards it was sort of taken into account. So the bill envisions overall sort of two tiers, several tiers of data. So there's personal data, then there's critical personal data, and sensitive personal data. And all of these enjoy different protections and a different sort of regime in which it's boxed under. There are certain overall it also envisions a data protection authority that can adjudicate on sort of issues of whether there was a violation of the act, and so what kind of appropriate remedies need to be rolled out, and also what kind of rules under the act need to be sort of, on what kind of SOPs or operating procedures need to be developed under the act. So in that way, it's pretty standard and share some of the same features of other data protection laws in other countries as well. But in terms of the definitions and the clarity that it provides, it falls short, for example, of other legislation such as the GDPR. So it fails, for example, to define things like public interest, critical personal data. And on the other hand, it also it has features of data localization. So for instance, critical personal data of citizens needs to be stored within the country, within the sort of regime that the bill envisions. And this becomes a big issue because we know that data localization comes with its own set of challenges. It can create more security issues. It can also lead to certain companies, for example, that house their servers elsewhere. They can incur more costs, and it can also lead to increased governmental control over citizen data without any checks and balances. And then another sort of issue is with the formation of the Data Protection Authority. So the authority itself does not have adequate independence from the federal government, and it also so it doesn't have administrative independence, which is a key feature of any sort of marker of independence of any oversight body. And furthermore, the act also allows the government to make blanket exemptions for itself. So essentially, it creates a hierarchy of what kind of data held by the government, which can easily be excluded from the data protection regime, and data by private companies who can't exclude themselves. But even we can imagine a situation where private companies are able to lobby with the government to make certain exceptions. So having such a big sort of a power of exception effectively makes the law in a way rudderless, because if in the future there's no certainty the kind of protections that will exist. So while there are certain parts of the bill that allows for sort of rights of the data holder, the right to erase their data, amend their data, but there's still a lot of things, and there's still a long way to go in terms of sort of making the entire system robust. And it really does depend on sort of these key features and the level of independence and the powers that the Data Protection Authority will have.
Thank you very much, Shmyla, and thanks for raising this point, because I think independence is very important. And another problem is that the federal government is empowered to appoint the chairperson and appoint other members of the committee as well. And there's no security of tenure that is given to the chairperson. So I think this is only going to lead into more political appointments like we see in any other public department. So thank you very much. Now my next question is to Hija and Zaheema. So another concern that I have is that consent is very heavily relied upon in this draft, and for some reason, and this is something that has not been talked about a lot, because there's this misconception that when you give your consent, even if it is in a way informed, but there are certain grounds, or if you're processing data, or if you're whether it's the data controller or processor, if they're processing data for a certain purpose, then a separate standard of protection should be applied in that regard. And consent is not something that can be used to trump everything. And therefore, when we talk about consent, like I said, there's a lot of misconception around it. And we see that in the draft as well. And consent is something that is, like I said in the draft, it trumps almost everything. Why do you think consent is not always the safest ground? And what can be done about it? And what is your opinion on it? So Hija can go first, and then Zaheema. Thank you.
Sure. Jannat, thank you first of all for giving the overview of consent and how the current data protection bill that we have lacks in understanding how it works also. And this is primarily a problem with Pakistan, and also abroad as well, everywhere, that people tend to not realize what consent is, and that's how a lot of problems originate as well in our cultural, social, and political, and also legislative conversations as well. And this is what we see translating in the data protection, the personal data protection bill that we have. Like you said, the consent seems to have trumped everything else in the bill. For instance, if the person has given their consent to collect and process their data, that's going to be the case for the entirety of their lives. While in fact, it should not be like this, because if somebody has given consent for one thing, they might not give consent to something else as well. And this bill currently does not address this. This bill fails to recognize the fact that consent needs to be irrevocable. And that's another problem with the bill as well. It does not allow people to easily revoke their consent that they've given for something that they thought was okay for them for the data to be processed. Now, another problem is that where they've said that consent is going to be taken, informed consent is going to be taken, individuals are going to be giving their consent, a lot of people do not understand what they are agreeing to. A lot of people do not maybe fully understand the extent of the data, extent of how the data is going to be used. For instance, if I've given consent to collect my data and store it on one server, I might not allow it to be passed on to a third party. And that's what we see happening in a lot of cases when it comes to any social media company, when it comes to any corporate entity, be it telecom companies, be it your food delivery apps, or even ride hailing apps as well. If they've collected my data for something, they are going to process it or transfer it for something else to make profits, which primarily is through their marketing strategies and everything. So this data protection bill does not address how it's important to put parameters for everything that the data is going to be processed, and to make sure that consent is taken every time, and one-time consent is not going to be applied for everything else. Because what companies also usually have done in the past and will continue to do in the future as well is, if they have taken consent one time, they're going to use it as a weapon to justify any processing of data that they've done. For instance, what we saw in Facebook's Cambridge Analytica scandal in 2016, Facebook had collected that data. Facebook had access to all of that data. Now, because some people have given access to all of that information to Facebook, Facebook is using it to make profits. A researcher comes on board and says that I'm doing everything, I'm doing the collection of data for research, and they allow him to do it. And what we see, how democratic processes are then stifled, or they are affected in the process. So Facebook did try to sort of pull it out of the situation by saying that people have given consent, people have agreed to give access to that data, and they've told that we're going to use this data for research purposes. But people whose data was being mined through that questionnaire, the researcher, however he's collecting the data, they might not understand the extent of this questionnaire or a game that they were taking part in, thinking that this is just another BuzzFeed style game that they're questionnaire that they're taking part in. So of course, these instances are not one-off. They are going to repeat. They are going to be around for a very long time. So the data protection, the personal data protection bill that Pakistan has, needs to address that consent cannot be universal. One-time consent cannot be universal. One-time consent cannot be used for instances of data collection and processing throughout a person's life. It should be revocable in a way as easy as it was given, through one-time click or through an application that is all online, and people do not really have to go in person, which this data protection law fails to offer.
Zaheema, would you like to add?
Thank you. Thank you, Jannat. Yes, in my reckoning, I fully agree with what Hija's been saying. Consent is not considered the most suitable and most safest ground for processing data, because at the end of the day, what matters most is data subject, and it leads to some of the grave and serious implications for data subjects' right. Since Pakistan Data Protection Bill, it lacks an effective safeguard for obtaining meaningful consent. For example, its clause 5, it doesn't offer any guidance, any clear guidance on how consent, more specifically, especially explicit consent, to be obtained. Moreover, the power imbalance between data controller and data subject and processor. I mean, there are likely chances that consent may be misused or abused by data controllers. The bill also doesn't carve out any requirement for how the consent is to be used, especially for the people, minors, or those who are not capable of giving a consent. As you've been saying in your question, that it's heavily relied upon consent, so it also shows that, and it links to that, it may allow or legalize some of the processes which are restricted otherwise. For example, cross-border data transfer by processors, or in automated decision in making, including profiling, and that too solely based on explicit consent. This bill, it allows processing for legitimate interests pursued by controller, but again the problem lies here that it doesn't define what these legitimate interests are, and it fails to include same that's been laid down in GDPR. Yes, having said that, alternate grounds that there are, yes, processing of personal data for the performance of a contract to which data subject should be a party, that there should be compliance with legal obligations to which data controller should be the subject, that we should protect vital interests of the subject and legitimize interests pursued by data controller. Thank you.
Thank you very much, Zaheema. So my next question is with regard to the GDPR. And as we all know that the GDPR, or the General Data Protection Regulations, uh, uh, they are considered an international gold standard. And although not everyone, might agree with that, but it is considered a gold standard. And but if we look at the Data Protection Act, that is even more robust in the sense that uh, it provides more protection. Its scope is broader. Its protection extends to the data that is processed by law enforcement agencies and intelligence agencies. So obviously the scope is broader in the Data Protection Act, but like I said, the GDPR is considered an international gold standard. And since this bill, it draws extensively from the GDPR, do you think it provides sufficient protections to data subjects, or do you think that alternatively the privacy laws in the US are more sector specific? So they have a separate privacy law for health, and then they have a separate law for financial data. And so which does make more sense, because then separate security controls and separate standards will apply to each set of data, and then it seems more reasonable and easily manageable. Because if you have one law, and then if you do not define personal data and sensitive personal data properly, and then you do not categorize how the law will affect small sized companies or medium sized companies or large companies differently. And then obviously all of these things have not been addressed in the bill, and this is something that is drawn from the GDPR, although it is more comprehensive, but it's still, there's just one law for everything in comparison to the US sector specific privacy laws. So what do you think would be better in the Pakistani context? Or do you think that since GDPR, I think like GDPR is more, it's anchored in human rights, if that makes sense, and it really focuses on the right to privacy. Uh, However, it's not the same when we talk about the US privacy laws. So if you guys could comment on what you think would be better in the context of Pakistan. Should it have been drawn from the US privacy laws, or is the GDPR like suitable? Whoever wants to go first.
Uh, First, like Jannat, like you have mentioned that GDPR is taken as a gold standard, and how it's been applied in the European law right now, we do see that companies make it a point to make an exception for the European countries when it comes to data processing and collection. We saw this happening when it came to the recent WhatsApp privacy change, policy change. There was a different policy for the European countries, and there's a different policy for the rest of the world. So clearly, it does seem like the US model is not working out for the people in the US either. So GDPR is giving certain kind of protection to people in the European countries. So I do believe that even in Pakistan as well, like GDPR and also DPA, as mentioned, different kinds of protections and different kinds of parameters for everything that is processed with regards to a person's data by any company whatsoever. So I think that model would be better for Pakistan if we intend to have something that is similar to GDPR. But of course, there are other concerns here as well, because European countries make up for a lot of say, for instance, a lot of profits for the companies, not as much as Asia collectively, or not as much as the global north, global south collectively. But because there are policies, because the servers are based there, because they are answerable to the policies that are to the policymakers in the European countries, they are of course more um, uh, more sort of receptive to the policies that are being made under the GDPR. But that might not be the case for Pakistani market, because one, we don't have a lot of in one country we don't have a lot of customers or a lot of ad revenue they can generate, or marketing profits that they can generate. But that does not mean they can make profits off of whatever is available in Pakistan. Having said so, I do believe that Pakistan, because is an emerging market, technologically and digitally, technologically and otherwise as well, there needs to be protections for people who are already on are digitally available, and people who are going to join. Like I said, Pakistan is increasingly becoming a digital world with the government's digital Pakistan policy, with the government's other initiatives with regards to making everything digitized. So there needs to be focus on data protection that offers unconditional protection to people, and not focuses on vested interests of the political parties or the political agenda that we currently see through a lot of legislations that are being passed. So in short, and to sum it all up, I do think that GDPR related model would work best, because we do see companies are adapting to it already, and companies would know how to deal with these GDPR related model or policy legislations that are being made, because of course they have a testing ground in Europe. Previously, we were the only testing grounds where the companies would come and test their products. We're still the same. We're still the market where they test their products. But at least when it comes to policy making, at least when it comes to changing their policies with regards to suiting any legislation, this does feel like a viable model that can be followed in Pakistan.
I can I can pick up what Hija was actually saying. So I do agree with a lot of points that she is putting forward, because I think it's while we can draw from certain legislations and we can learn from best practices, you can't account for a copy paste sort of job is never good, because there's a different dynamics. And with the data protection law, the sort of subjects are both sort of you are trying to regulate the government and government entities, and at the same time private companies. And a data protection law in this day and age is also more complicated, because a lot of the companies are not located within Pakistan. So the efficacy of any data protection law of from a country like Pakistan, where we don't have tech giants located, we don't have servers. So even local companies that are using servers, for example, Amazon servers, they're not located in Pakistan. So the sort of scope of such a law and the effectiveness of a law is determined not just by the law itself, but the politics around the law and the way that the law is framed. So I think those are that is something to take into account, and it's quite dispiriting sometimes as well, because there are a lot of things that maybe the law can't account for. And secondly, like sort of, I feel like both the US model and the GDPR model might be a good fit in if we sort of pick and choose. So I think the overall framework that the GDPR provides in terms of rights, the kind of sort of oversight mechanisms that it provides are very useful and can be replicated, because I would imagine that a data protection law comes at the federal level. So there it sets like an overarching framework. But I think it can also allow or empower the authority to have specific rules for each sector. So, like you said, like sort of medical data does require a certain considerations. For example, public health, especially as we saw during the COVID pandemic, there are certain different uh, considerations that will go into something like this. Then, when we think about, for example, data relating to specifically like someone's that is held by NADRA, would be very different than data held by private companies or apps that are developed. So I think we can make it much more tailored, as long as it is all held together by a larger sort of federal law that can allow for accountability at the federal level. And so, for example, like sort of certain departments can be empowered to sort of have their own rules. Now, I think in a country like Pakistan, where there's been so much sort of feet dragging when it has come to just the bill, I think maybe a sectoral approach might be difficult to execute, because then you need to make sure that every department is on board, or whichever sort of body is designated that. So these are non-legal sort of interventions, or sort of, I guess, like considerations that we need to take into account what is feasible given the way that things are in Pakistan. And then secondly, thirdly, I think a data protection law is always very good, and it's a very important stepping stone. But unless we are able to sort of challenge and systematically sort of break down the power of big tech, a data protection law can only go so far. So even in the European context, like sort of they incur fines, but they still go on like sort of repeating those same practices over and over again. And that is because so much power has been accumulated in the hands of the few companies. And so I think globally, I think there needs to be a push for sort of antitrust legislation that can regulate and seriously break down sort of the monopolistic and the predatory power that these companies have. That, I think, along with data protection legislation and interventions, can go a long way. And I think any law in Pakistan would be different, I think, from both the European and the US approach, because at the end of the day, Pakistan, as Hija said, Pakistan is a country where digital literacy is much lower, where even sort of the awareness that individuals have of their rights. So both these frameworks imagine a certain kind of data subject that sort of is empowered, it is able to understand, for example, the notices that you are given, is able to understand sort of the larger ways in which their data can be used and mined and exploited. So I think they end up putting a lot of onus on the individual. Whereas I think in Pakistan, we will have to sort of maybe go a step further, because a lot of people won't be able to sort of maybe even read notices, how those notices will work. I think we need to come up with a much more contextual sort of and local approach to how these notice requirements and sort of awareness requirements are, given that literacy is so low and digital literacy itself is so low. So those are, I guess, like we'll have to be more creative. Whereas at the moment, there seems to be much more of a like copy paste situation going on, rather than like really taking the time to creatively think about these issues.
Thank you. Yes, being the last speaker is always, it's always, you have left with very less to talk about, because my co-panelists, they've almost covered everything. But yes, I agree with them. GDPR, yes, it's a good benchmark to follow, because it is consumer focused. It talks about objectivity and privacy. As compared, if we look at data protection laws and regulations across the globe, GDPR is considered and marked as one of the toughest laws in terms of implementation. In US, their laws, as my co-panelists they've talked about, they're separate separate laws, they are sector specific, or HIPAA, that's health related, or there is another new one, the CIPP. But again, they don't cover everything, and that they're not with Pakistan's context, they don't really, good to be followed. Secondly, because what I think is we live in an interconnected world. The cost of doing compliance and ease of doing business would be little higher because of GDPR. Obviously, in all countries, they have to put some sort of laws and controls or measures in place for the companies to comply with. But again, it will increase the cost of doing business. There would be compliance ecosystem sort of in which, they have to maintain all controls and HRs and technology and processes as well. So it would be a little difficult if we talk about people, process, and technology context. But yes, on the other hand, if we look at any uniform laws across the world, or at least they are based on some principles, so cost can be minimized. If we talk of there is no law to be followed, then yes, security is compromised. So we cannot go for that. So we have to follow at least laws. If we, in terms of companies, I mean, for any the data controller processor company, if it has to follow multiple laws for doing same business, so the cost it eventually goes up. So law is based on unifying principles. For example, same principle for data processor, controller, right to privacy, privacy by design, etc., etc. So eventually, cost of compliance and cost of business, they can both come down. So yes, answer is if a benchmark such as GDPR is emerging and all countries should follow that, so it would be easy for companies to comply with the same baseline. Thank you.
Thank you, Zaheema. My next question is for you. You talked about the cost of doing business and the cost of compliance. Could you tell us about the obligations that the current bill imposes on data controllers and processors? And what do you think, if you could tell us about these obligations and how easy or difficult you think compliance will be from a commercial standpoint and as well as a cybersecurity standpoint?
Yes, sure, Jannat. Obligation of data process and controller, they are significantly important because these organizations have to comply with laws if these laws are clearly spelled out. I mentioned earlier that data controller processors or custodians, which may not be nation state, but technology companies. And today, technology companies are enjoying their power beyond the regulation of nation states, and states are failing to provide suitable guidance for them to comply with. We've recently seen an example, and that was a technology company has suspended the Twitter account of a sitting president on the basis of violence and incitement. Have that same incident or example here in third world country or here in Pakistan. So do we think the technology company would go for the same legal grounds to suspend the account? I don't think so, as far as my humble reckoning is concerned. So in Pakistan data protection bill, yes, there are obligations for data controller and processor. For example, they need to take consent from data subject if the data is processing, including sensitive personal data. Then there is another that they cannot process their data unless for a lawful purpose, and they should have to write in written. They have to inform data subject. Then there is another obligation for the data retention, that they should only be used until and unless the purpose is served. That they also need to take steps to ensure that the personal data is accurate, complete, not misleading, and up to date. There are other obligations for data controller processor, that they should immediately inform the data subject if there is any security breach. Having said that, there is another cross-border transfer of personal data as well. Having said all this, it requires data controller and processors to nominate its representative in the country. However, it doesn't specify either it is for all data controller or processors or any social media companies. For ease of doing business, as you said, we need laws which are easy to comply with by the controller and not too rigid for data for technology companies to comply with. So I think we need to go hand in hand. We need to take into consideration three main actors, that is data subject, nation states, and yes, technology companies. There should be a framework suitable enough for companies to have ease of business, and same customized framework for cross-border data to address the concern of nation states. And yes, keeping in mind and keeping in consideration the rights of data subjects. Thank you very much.
Thank you, Zaheema. Before I go on to the last question, I just had a question in mind. You talked about data retention and how in the cybercrime law there is at least it mandates telecom companies to store citizens, data for at least 1 year. Um, which includes traffic data and other types of data. However, what we see in the current data protection bill is that now they've changed the requirement. And like I said, there's no categorization, everything is so generalized. And even when we talk about social media intermediaries, they're not specifically mentioned in the personal data protection bill. But we do have the social media rules now, and they talk about cross-border transfer. So they're basically addressing the same things, and they're just focusing on the social media companies. However, in the personal data protection bill, there's no mention of social media companies, but because the very broad and vague definition that there's been given, and how there's a total sort of prohibition on cross-border transfer of data. So there's a lot of like overlap and contradiction as well, even when we compare this personal data protection bill with PICA or with the rules that have recently been brought by the government. So any one of you can answer this. So just I don't understand if so if we look at how these social media companies uh, um, how so the rules, they do provide a mechanism whereby people can report content, the content will be taken down, and also a mechanism whereby the government can request data from the relevant social media company. And then we also know that there's a law that was recently passed, and it talks about how Pakistani agencies can request information from regarding criminal investigations. So we do have a mutual legal assistance treaty law in place as well. But there's a lot of confusion, and it also does not specify that it is only for specific reasons such as money laundering or other such crimes. But I don't really understand which law do I have to look at every so if I'm in the context of social media companies and how social media companies are regulated in the context of Pakistan. So I do have the cybercrime law as well, and then I have the rules as well, and then the data protection bill. So I'm not sure if I should only find all these answers from data protection bill or the rules, because they contradict with each other. And then the act also contradicts, which is the parent act, and but it still contradicts with the rules. So there's a lot of confusion, there's a lot of overlap. And even when we talk about how when we talk about online spaces and how they're regulated, there's a lot of overlap as well between the FIA, PTA, and PEMRA. So could any one of you comment on how online spaces are over-regulated in Pakistan, and how difficult it is, especially in the context of how social media companies are regulated in Pakistan, because the rules say something else, and we have totally different rules for perhaps we like I said, there's no categorization. So there may be a company based somewhere abroad, and different rules may be applied to them in comparison to social media companies that may be based in the same country and maybe of the same size. So there's a lot of confusion in relation to this. If you could, give some clarity on this, any one of you.
Yeah, so it feels like that the rules, social media rules, are more of an aspirational document than something that has been thought through properly. So, for example, it includes Rule 9 of the social media rules that have been passed, but and are currently under challenge at the Islamabad High Court. So, and the Attorney General is also sort of reviewing them and holding consultations. So the status is not entirely clear. But Rule 9, for instance, says, at least, or aspires to ask social media companies to provide data in a decrypted form. Which is something that is quite unprecedented and has not been. Other countries have tried it, but it's I haven't seen examples where social media companies have fully complied with decrypting data when it is, for example, for a messaging app like WhatsApp or things like that. So the sort of kind of understanding, I think, that is coming from the government is not doesn't really map onto the existing realities of online spaces and what is even possible. So the social media rules, while they derive their mandate from Section 37, have gone on to legislate on sort of on things, and I would say legislate because they go beyond the scope of what a rule should do, to talk about things like, for instance, like privacy and how data should be procured, which doesn't really fall under the ambit of Section 37, which is just about blocking and removing content. So there isn't a lot of clarity, and there's I think a lot of impatience on the part of the government to sort of regulate these spaces that they don't entirely understand. And that's why a lot of these issues are coming from. And that's why a lot of patchwork of legislation and rules that might at times overlap, contradict each other, is emerging. So I think there is a fundamental issue here as well. And I think that is why the rules themselves have also been challenged, and it's very unlikely that they will be upheld in the same form as they have been passed in, because of this lack of foresight and this lack of sort of really thinking through the different pieces of legislation, and especially when a data protection bill is actually sort of under consideration, for the rules to go beyond sort of the ambit of what even the bill envisions in terms of decrypting data, how that data sharing will happen. That is a big issue. And I think the government is not entirely clear about how to sort of govern and how to get data from social media companies. So even within the bill, when it talks about data localization, there's no framework for what this will look like, what the safeguards will be. Again, it seems like sort of because of a failure of imagination almost, to sort of how do we get this data from these companies that are not registered here? Let's just ask them to move their servers. Does questions like, does Pakistan even have the capacity to host data? Does it even have the sort of technical capacity to host servers? I think all of this is it really are question marks, and will actually lead a lot of this legislation to be unimplementable. And what will happen is that what is happening with the PTA currently, that they will almost discard what the legislation really says and acquire sort of when institutions, the legislation and the rules don't match up with what the institution wants to do, the institution will then overreach and do sort of things that are beyond its scope, and it'll create this untenable situation. So I think the same, unless these rules and certain parts of these of the bill are revised in terms of practicality, realities of where Pakistan stands, and what I don't think they'll be implementable, and then we'll have a situation where the governing authority will just make up rules or sort of acquire more uh, um, powers when there is a vacuum and ambiguity. So I think we need to anticipate all of these realities, the consultation process for this for the data protection bill was there was such a short time in which it happened. It wasn't transparent. The government needs to justify, for example, like sort of when you do a consultation process, if they people release white papers where they justify each the thinking behind everything, they respond to criticisms coming from civil society and the tech sector. There is that dialogue that has not happened, and it really reflects, and that's why there is this haphazard and there is this confusion. And I think what needs to happen, I think, is for lawyers to really sort of point these out when certain cases come to them. There are obviously constitutional challenges to the rules, but for example, when the law is passed, the data protection law, at every stage, I think these contradictions and these sort of overlaps need to be pointed out so that there is clarity. If it is not coming from the legislation, maybe it can come from the courts.
Thank you very much, Shmyla. Hija, do you think there are any specific provisions in the bill that violate fundamental rights? And do you think there are sufficient protections or remedies available in the current version of the bill?
Sure. Like Shmyla has said, and I'm going to build on what she has said with regards to answering this question as well. The data localization bit of the bill is particularly personally pretty worrying for me because, like Shmyla has also said, once the data servers are localized, what happens next? What are the protections? What are the basically what are the remedies for people when and if their data is breached? So as Shmyla has also said, that it seems like it just looks like the motive was to localize data, so to have easy access to it. We have seen similar instances happening in Turkey, for instance, where a similar set of legislation was passed in the past couple of months, where social media companies were told to assign a representative in the country and prioritize giving information or data to the government as and when it's asked, without any questions, without any concerns regarding why that data is being asked for, how is it going to be used, etc. And we see the similar model replicating in Pakistan, essentially in the light of the social media rules coupled with the data protection law. We have fine, so data localization has happened, cross-border data transfer has happened. What next? Given our country's history with regards to protecting fundamental rights, protecting civil liberties on the internet, we have seen how freedom of speech is affected, how right to privacy is infringed for people on the internet and offline as well. Easy access for the government to on people's data is going to affect freedom of expression and people's privacy as well, more so for activists, dissenters, journalists, etc. Because we do see that there is a hostile environment being made for any kind of people who criticize state policies, people who criticize or have opposing views with regards to how the government is functioning, what policies are they making. So once my fundamental concern from this law is, while this is supposed to be protecting people's data, in the name of protection, it's just another mean to control people's online activities and their data as well. So I don't see any protection being offered under the personal data protection bill. And so that's what we saw in the cybercrime, in the context of cybercrime law as well. When it was passed, it was heavily criticized before 2016. And civil society and all the other relevant stakeholders basically chalked out all the concerns that they had and how that law is going to infringe people's rights. But that was not regarded, the concerns or the criticism was not regarded, and what we currently have does not protect people on the internet, but it has become a tool to stifle dissent, stifle freedom of expression. It has been used against women's rights activists, journalists, and actors, generally any human rights activists as well, to silence them. And this is what I see will happen with the data protection law as well. It will become a weapon to attack civil liberties that people have, the rights that people have currently protected under the Constitution of Pakistan.
Thank you very much, Hija. And since our time is up, I will not be able to take comments from Shmyla and Zaheema, but thank you so much, everyone, for being a part of the Women in Cybersecurity, and also for this very informative and very insightful discussion. So thank you very much.
Thank you so much, Jannat, for having us.
Thank you.
Thank you very much,
Thank
Jannat.
you.